Subscribe to The Honest Critique for current affairs, movie, book, and product reviews. Also, make sure you press the bell icon to get notified whenever we upload a new video. The views, information, or opinions expressed during the video series are solely those of the individuals and do not necessarily represent those of The Honest Critique and its employees. The following video contains strong language which may be offensive to some viewers. Viewer discretion advised.
So hello and welcome to The Honest Critique, where words and stories are our infinite space. On this platform, we strive to decode complex societal matters, address larger public policy matters in the country, and track down regular legal and policy developments that engulf the discourse. Today we have with us Mr. Kazim Rizvi, co-founder of the think tank Dialogue. And we are going to discuss the issue of the incoming data protection bill and the issues that surround the tech regulations in India. Mr. Rizvi is the co-founder of the prolific think tank Dialogue, which engages in critical research on tech-related matters, as well as engages in policy consultation with several government bodies and other civil society organizations. It has been ranked as one of the most promising think tanks of the country to watch out for recently, last year. He's an alumni of the Christ University as well as a lawyer by profession. So thank you so much for joining us, sir. My first question to you, and setting a little bit of context here, it is the year 2022, and it's almost been 4 years since the historic landmark judgment declaring the right to privacy was declared as a fundamental right. But the data protection bill that was essentially in pursuance of that, from its evolution, has undergone tremendous multiple revisions and changes to its framework. But the basic structure or the baseline being that primacy will be given to protecting the data rights of the citizens while simultaneously upholding national security concerns and subsequently making room for governmental intervention. Every single policy decision, every single tech advancement happening in the country brings us back or circles back to the conversation or the question that the lack of data privacy bill in India is something that needs to be addressed. And without having an adequate framework governing the citizens, the threat to the data privacy looms large. So setting the context here, what is your take on the roadblocks and the road ahead as far as the passage of the data protection bill through the parliament is concerned?
Thank you so much for having me to. Thank you to the Honest Critique for inviting me to speak on tech policy related issues, and it's a pleasure to talk to you. So I just want to sort of go back a little bit from the discourse around data protection and privacy to look at the evolution of internet and what led us to the right to privacy, and then where we are today. And if you see in the 1990s and the 2000s, when the internet started becoming mainstream, we've evolved from a place where we've been using internet for emails, for basic services. From there onwards, in the 2010s, it has become something of a very mainstream and a very important essential commodity for people to use in order to sort of go about their professional and personal lives. And the digitization, which has been taking place over the last, let's say, 8 to 10 years, has really brought the importance of privacy in the global and national discourse as well. So we've been seeing that a lot of data businesses have come up. There are companies which are providing services, collecting data, processing data, and etc., both government as well as private. So with this rise of digitization, there was a need felt by the Supreme Court that we should have a right to privacy. So in 2017, the Supreme Court guaranteed a right to privacy. From where onwards, we started having the discourse to a data protection bill in India. Now, the data protection bill has seen significant changes over the last 2 years as it underwent rigorous deliberation by the Joint Parliamentary Committee and which was entrusted with relooking at the legislation. With the expected introduction and passing of the newly data protection bill in this year, we are sure to see a paradigm shift on how businesses work, collect, and process data. while at the same time, we are also looking at restrictions around cross-border data flows, along with comprehensive duties laid out for data fiduciaries as well as data processors. Uh, Another key development, which I think is taking place right now, is the setting up of India's first data regulator, which is the Data Protection Authority. And this is going to be a very important step towards making sure that the data protection bill is operationalized effectively and has smooth implementation. In terms of regulation of non-personal data, the inclusion of the same within the purview of the newly proposed bill is an interesting development. While at the same time, there is already a committee of experts led under Chris Gopalakrishnan, which is looking into the regulation of non-personal data. So we are looking at an area where there may be certain regulatory overlaps. Now, in terms of the roadblocks and ahead, like any policy change or regulation, there will be certain sort of hiccups on the way to legislating India's first data protection law. In the short run, there may be added cost, there will be change in processes for companies, for fiduciary, but in the long run, we see that higher compliance requirements for businesses with a higher threshold for privacy respecting practices is a step forward in an increasingly digitized world. And it is critical to implement such measures to protect users' data and provide them ownership and agency on how the data is processed, collected, analyzed, etc. So the idea for the data protection bill is to make sure that the user gets the ownership of his or her data. And this is likely to bring about change in how we view privacy as a right. Now, there are multiple challenges which we see with the current data protection bill, and there are a lot of opportunities as well with how the bill is being processed, is sort of coming through. Let's just talk about that a little bit. I think first of all, it is important to make sure that the bill is harmonized and interoperable in nature. Now, what do we mean by that? Data is now cutting across multiple sectors. You're looking at data in the healthcare sector, in the financial sector, in transport sector, in across multiple fields, multiple economic services. Data plays a very critical role. So what is really happening is you have sectors which are sort of operating in a traditional manner, and then data cuts across them. So the data protection regulator has to make sure that the bill and the way it's operationalized is harmonized with multiple regulations and legislations through which it has a relation or it intersects with. So that's number one. That is very critical. Number two is that the data protection regulator has to be also harmonized with multiple other regulators. So RBI, TRAI, telecom data, healthcare sector, etc. So SEBI, etc. So all these regulators, the data protection bill, the data regulator has to be harmonized and work in accordance and make sure that it works seamlessly with other regulators. This is domestic harmonization. Internationally, it is important that the bill is interoperable in nature, is interoperable with global data protection ecosystems, such as the EU GDPR, which is the gold standard in global data protection laws, as well as with other data protection regimes such as Japan's and the American data protection regime, the UK's data protection regime, etc. Now, over here, it is important to understand that we need to have a data protection bill which has a very seamless intersection with other data protection regulations to allow data flows to take place between multiple countries. And it is critical for India's trade objectives as well as security objectives that India enters into bilateral data transfer treaties for law enforcement as well as for economic outputs, both. Over here, to achieve this, it is critical that our data protection laws are then harmonized with other data protection laws for us to enter into these agreements where we can get access to data and we can also capitalize and participate in the global data flows ecosystems, which will help in growth of AI, which will help in growth of our startups, which will allow our companies, our tech ecosystem, not today, but in the next 5, 10, 20 years to create services for the users and to access the best products and the best amount of services available on cloud servers across globe and also with other data protection ecosystem and other companies as well. So I think that is something which we have to focus a lot on. Fraud prevention is critical, and having a seamless global data flows ecosystem allows us to do that. Uh, then there are further roadblocks, with how the framework is looking at present, with certain suggestions have been given by the Joint Parliamentary Committee, and the Ministry of IT and the Cabinet will now be looking into those recommendations, and we expect the new version of the bill to come soon in the Parliament. So there are some other areas which we would like to focus a little bit more here. Moving forward from the global data flows discussion, we also need to make sure that the DPA is independent, right? I think that's very critical. It should be transparent in its functioning, it should be independent in its functioning, and there should be adequate judicial oversight with how the Data Protection Authority is operationalized in India. And independence of the DPA is critical to the success of the implementation of the data protection law. It will also give India an additional advantage, because to achieve adequacy status with EU, US, UK, and other countries, independent DPA is a critical point. And if you have an independent DPA, then you can negotiate with other countries on adequacy status, which will then give you the opportunity to enter into data transfer treaties. So I think that's an important point which we have to focus on. Going forward, another key discussion which is going on is around platform regulation by social media intermediaries, and also whether social media intermediaries should be considered as publishers or not. Now, the committee in its report talks about this, and we believe that it is important to make sure that platforms are transparent and accountable in their actions and in the way they are going around content moderation. But at the same time, taking away intermediary status from social media platforms may lead to a major overhaul of the entire platform regulation ecosystem. It could also lead to over censorship on the case of the platforms, because if they are not considered as intermediaries, then they may start over censoring content and deleting content, which could have adverse implications on users' free speech on the internet. So I think that is an important area for discussion. Then again, we've seen that the current data protection bill includes non-personal data as part of the data protection bill, which has been proposed by the JPC. This could lead to regulatory overlaps. There's already a committee which is looking into non-personal data. Number one. Number two, the objectives of the Personal Data Protection Bill and the Shri Krishna Committee, which was formed in 2017, as well as the Supreme Court judgment, was to come up with a law to protect user data, to protect privacy, which is personal data. Moving away and broadening the scope to a general data bill where you have non-person and person data may complicate the regulatory aspect and may also have regulatory overlaps. We need to look at these two things separately. I think that's an important area, and we've suggested that in our paper, in our preliminary analysis, which we published last month. Moving ahead, another concern which has been brought about is exemptions to the law enforcement agencies when it comes to state access to data. I think clause 35, which looks at exceptions to the state to process data for national security concerns, there has been a statement which has been added, which reads, the inclusion of the word which reads, processing should be just, fair, reasonable, and proportionate. However, the committee has not looked into narrowing the scope of the exemptions per se. The scope of exemptions have not been narrowed. They are as they were in the previous version, in the 2019 version of the bill. So I think we need to be very sure that the scope is narrow, the scope is defined, because at this stage, even now, in its current avatar, the clause 35 does provide wide exemptions to the state when it comes to access to data for law enforcement purposes. Surveillance is important. Targeted surveillance should be more targeted. It should not be mass surveillance. It is important that law enforcement agencies have sort of a window to operate under, and there are adequate checks and balances. We do not have surveillance reforms currently in the country. What we need going forward is adequate judicial or parliamentary oversight when it comes to surveillance. And through clause 35, there is an opportunity for the government to introduce those reforms by narrowing the exemptions when it comes to states' access to data. So I think these are some of the key areas which we've been talking about. There are additional discussions on hardware regulations as well. Again, there are multiple regulators and regulations where hardware is regulated, and there is adequate checks and balances to again bring hardware regulations in the ambit of the data protection bill might lead to regulatory overlap. So we have to be very careful in terms of making sure that the personal data protection bill is clearly preventing abuse of user data. It's protecting the users. It's having adequate checks and balances for law enforcement to do their job as well. It's interoperable globally. It's harmonized domestically. The DPA is independent, and it's clear when it comes to protecting personal data, and there are no regulatory overlaps or complications uh, to make sure that the bill is then operationalized effectively.
So I thank you so much for setting the context and contextualizing the conversation in a way, because my second question was based on going into the greater details of the bill. But you've already,
I'm not able to.
am I?
Can you repeat yourself? I think I couldn't hear you. Yeah, if you can repeat
Um,
yourself.
what I said was that you've already gone into the
Yeah.
greater details of the bill by setting and contextualizing the conversation that lied ahead, which was doing a sort of clause by clause dissection of the bill, and what the bill holds and what's the future like. So I'm going to be very, very specific in the next question, which is the efficacy of the bill. So we've already discussed to a large extent what has been the outcome of the joint parliamentary committees, the independence, and keeping in mind stakeholder management, keeping in mind the contentious IT rules, which mention about intermediaries and blurry lines between intermediaries and publishers that you also talked about. Um, how far do you think that the data protection bill is instrumental in containing the powers, the overarching powers of the big tech companies, when it comes to they having, that power of monetizing on user data, and as well as issues of data localization, which repeatedly comes either in the dissent notes or either in the uh, backlash that comes from the civil society side?
So I think there are two parts to your question, and we'll take each part separately. So let's first talk about big tech regulation and checks and balances. I think the data protection bill does a great job when it comes to placing adequate checks and balances and also procedures for not just big tech, but any tech company, data fiduciary, which is in the business of processing personal data, right? So I think there the data protection bill has done a great job in terms of introducing a process for companies to operate within the boundaries of that process to make sure that the user's data is protected and the user gets adequate agency and ownership of his her data. We must understand that we are moving from I would say, an ecosystem where we did not have a data protection legislation or a data protection regime to taking the first step towards developing and building a data protection regime. So I think we are taking that first step with this maiden data protection law. And definitely we are going ahead and moving in the right direction when it comes to protecting users from corporate usage of data and monetization, etc. When you look at the data protection bill, it talks about the purpose for which data should be collected should be clear. Data minimization principles have been brought in the bill. If you're collecting data, you should be collecting minimum data for the services you're giving. The purpose has to be defined and clear. The time for which it is collected should be clear, right? There is also right to be forgotten. Then, of course, there are discussions around how the data is stored, etc. as well. So I think when it comes to the entire life cycle of from collection, processing, and collection, processing, and then going forward from, let's say, monetization and then using, etc. There are clauses in the bill which look at these areas, and then there is also auditing of how companies are really implementing this bill. So there are checks and balances placed in the bill when it comes to auditing. There is a regulator whose duty is to make sure that breach is reported, and companies have to report breach if there is a breach of user data. So I think there is a lot of good things when it comes to the personal data protection bill protecting users from data fiduciaries, let's say, protecting users from the how Data could be, let's say, abused or stolen or breached, and also making sure that they have enough ownership and their data is protected from any usage which they have not authorized it for, right? So I think there is consent as well in the bill. So all these aspects have been covered. What is important to understand is that we need to make sure that it's covered across data fiduciaries, which is public and private, both. So I think that there is some more work to be done to bring in the government and to make sure that the state is also held accountable, and the exemptions are narrow. On the localization point, I think over the last 4 or 5 years, we've been seeing the localization debate take place, and many times we've had this binary of tech versus government, and we've seen this binary of okay, is localization good or bad? I think we need to sort of move away from these binaries and look at it from a user perspective, and look at it from a startup's perspective, and also from a security and privacy perspective. On all these four pillars across which localization debate should be looked at, I think it is important to understand that A, India's national security concerns are legitimate and valid when it comes to access to data for law enforcement. Number one, we've seen that currently in the existing legal processes, we have something called an MLAT, which is a mutual legal assistance treaty, which allows India to seek access to data from foreign jurisdictions if it's investigating a crime. MLAT is a really tedious and a slow process, and it takes months to really get access to data, by which the investigation agencies require data much faster, and by which it's too late to actually do something, because on the internet crimes are taking place and you need to move and act fast and swiftly, because you moved away from traditional physical world to the online world where things have to be much faster, so you have to act swiftly. Now, to tackle this problem, government believed, and there are a lot of discussion happening, that should we localize data in India so that we get access to data for law enforcement as and when we need. Now, although the intent is correct and intent is legitimate, we've seen that localization doesn't really add up or will help law enforcement agencies to collect data or access data. Number one. What is required here is to enter into data transfer treaties with countries through which India can access data as and when required. For example, the US has a Cloud Act. And if you enter into an agreement with the US government through the Cloud Act, you will be provided, your agencies will be provided access to data as and when required. And there's a process which is fast, which is timely, which can help law enforcement tackle and solve crimes effectively. Localization per se will not help, because even though you may store data in India, the access has to be done through the existing processes. Number one. Number two, another point for localization has been that we need to build our data center industry. We need to sort of enhance our own data processing industry. I think that's a very legitimate and a very positive argument. There is a need to build India's data center ecosystem, but that can be done even while you allow companies to store data abroad on servers as well. What we need is competition. Bring in the Indian data center industry, allow Indian data centers to flourish, while at the same time give companies and startups a choice if they want to store data in India or abroad. We've seen that many startups, even before the localization mandate was imposed, were storing data in India, and some of them are storing data outside as well. So there is a very healthy competition going on between India data centers and global data centers. I think that's something which we need to promote. The challenge here is restricting data flows. The problem is not localization per se. We should promote our localization, our data center industry. What we should not be doing is telling companies to say you only should store in India and you cannot store abroad. I think that is something of a restriction which we need to relook at. So why is it important to relook at it? One, security perspective, it doesn't change anything. What you really need is a data transfer treaty. Number two, you can still grow your domestic data center industry by allowing companies to store abroad. Number three, we've also seen that the cost of data storage is higher in India, and there are many services which companies may want to use from cloud storage service providers, which may or may not store data in India. So I think that option should be given. We did a study last year where we interviewed around 40 to 50 startups in India, and unanimously, predominantly, most of them were of this opinion that cost of data storage will go high if localization is imposed in strict terms. While on the other hand, if you say, okay, store in India, bring in India, but we also give you the option of storing abroad, but we want to promote our data center industry, I think that would be a right step forward. So the intent is correct. Intent is great from the government, but I think the way we implement the policies is something which we need to relook at. So I think these are the sort of four areas, in terms of cost, in terms of law enforcement access, in terms of data center industry, and also in terms of economic opportunities. Because, for example, if we want to be, if we want our startups to be part of the global data services, and the way AI is going forward, AI requires multiple data sets to be sort of accessed from different points of time. I think for our startups to operate in that sort of circle, it is crucial that we allow data flow so that we can also harness and use and sort of go and set up our startups abroad, right? So for it will be great if we have Indian startups, operating from the US, from the UK, setting up offices there, processing the data over there, setting up the industry over there. That can only happen if we allow data flows from India to take place. So then you have a mutual sort of a data flows
Yeah,
from the
yeah.
foreign jurisdictions coming into Indian startups, and then that will allow the growth and sort of proliferation of AI technologies, because that requires a lot of data set from different jurisdictions. It will also help in fraud prevention, because fraud prevention, real-time fraud prevention depends on global data flows. And if India is isolating itself and sort of moving away and becoming an island, then Indian companies cannot participate in those global fraud prevention services, which will help India to counter cybersecurity, sort of cyber breaches, sorry, and to enhance its own cybersecurity ecosystem. So I think this is a critical debate which has to be looked at from multiple angles, and we need to move away from the binaries on this.
Absolutely. I think there can be no straight jacket formula. And further, like you explained,
Sorry, I can you repeat your question? I think initially there's some
can
lag.
I,
Yeah, yeah. Now,
am I audible now?
yeah. Can I
So,
just take a water break? Yeah.
sure, please go ahead. In fact, I am the one who's having warm water. It's the
Yeah,
situation
I
is
think you should.
terrible. The situation is terrible in
I
Patiala,
know.
actually. Um, so
Oh,
I
you're in
was,
Patiala.
yeah, I'm based in Patiala and I did my law from Chandigarh. So
Okay, okay.
I immediately after you stop answering a question, I summarize it. I don't straight out jump to the next question. But my next question
Okay.
is also a subset of a specific pattern that you've been talking about. Like the finer points being that I don't know if you've heard about the legislation. I'm sure you must have the DNA technology use and application regulation bill 2019, which has also seen the same kind of trajectory that the data protection bill has. Now that bill specifically advocates for digital intervention in the criminal justice system with under the pretext that it increases efficiency in crime solving, but along the same lines it also gives unabated powers to law enforcement agencies and what all the institutions that the bill covers and talks about. What does this say about the right of accused, the culprits? How does it define, and whether there are any procedural safeguards are there at all in place as far as the bill is concerned, because there has been multiple revisions and a lot of debatable and controversial aspects of the bill have come out in public light. So what are your views on that?
So the DNA Technology Bill 2019 essentially covers the use of DNA technology for the purpose of establishing the identity of certain persons. Now, the bill covers aspects such as the use, collection, and storage of DNA in a, let's say, DNA data bank. It does set up a regulatory board to govern this infrastructure created by the bill, including, let's say, accreditation to laboratories that are handling DNA or storing it. It penalizes offenses and such as disclosure of DNA information and non-authorized use. Um, However, I think, just a second, sorry. Yeah. However, I think in effect, when the bill does what the bill is, I mean, it allows the government to obtain genetic information about crime victims, accused missing individuals through collection and store this data for extensive periods. Now, there have been many concerns which have been raised about the privacy harms, associated with the creation of such honeypot of sensitive genetic material like DNA. DNA has the ability, after being studied, to reveal information about an individual, right from being able to identify an unidentified dead body. It can also be used to trace one's ancestry. So the main debate is that a tool that will definitely help aid law enforcement to some extent to achieve better results in closing cases. But at the same time also has a large potential to be used as a tool to profile and exclude any targeted community as well. So I think we need to be sort of very careful with that. Um, at the time when the bill was discussed, India had no privacy legislation. Of course, with the PDP bill not yet having been introduced in the parliament at that time. However, even where we stand today, the bill has not looked at DNA information in particular and laid down any additional specific protections pertaining to this form of collection and usage. So it is imperative that we strengthen our policy infrastructure for the privacy and safety of health and genetic information, and ensure that the law in this space is created before the systems are employed to ensure that the fundamental right to privacy of citizens is not infringed. So what we really need is, I would say, first and foremost, a baseline data protection bill which protects and ensures privacy of users. Any further bill or regulation or policy which is looking into processing of person data has to be harmonized with the baseline data protection bill, and only then should we move forward. So I think that is something which is very important.
Yeah, again, it's the same pattern essentially, and all of that
I
circles.
think I'll, yeah.
Uh,
Can you again repeat yourself?
I'm saying that the problems and the issues that exist or are entrenched within the DNA bill is something that raises, even like, it raises the importance of having a data protection bill in the first place to cover that vacuum, essentially. Am I audible?
Yeah.
Okay. So my next question is, I mean, I wouldn't say that India is a focal point or it has seen a large amount of breaches when it comes to health data, but I would definitely say that this is a sector that is in need of regulation. And when it comes to the interjection of data protection bill and telemedicine applications and securing sensitive health data that comes under the clause of sensitive health data, the way it is defined in the PDP bill. Now, if you have to compare it to the United States of America, which has a very strong piece of legislation, that is the HIPAA, and it clearly distinguishes between who are the crucial stakeholders, like who can share the data, like the role of the third parties, backing of the insurance companies, and all, that ecosystem is very well defined and established under that act. But when we come to the landscape in India, and we talk about securing personal data, securing critical health data is concerned. And now with the onslaught of use of telemedical applications like the Practo MG, which has been increasingly used by healthcare institutions, Arogya Setu app, all of these policy interventions and advancements, what does this say about the vacuum, and how do you think that we deserve a separate piece or an exclusive piece of legislation on health data, or do you think that the PDP bill, if and when it comes into existence, would be enough to deal with this larger construct of health data?
So I think there are no legislation when it comes to laying out the red lines when it comes to health data. Digital healthcare is a promising prospect. It allows for more efficiency in delivering healthcare if evolved with user welfare in mind. As with any digitization effort, the data trails that such an effort leaves, it's substantial. And in the case of health data, it's particularly risky if, let's say, bad actors get access to it. So definitely we need to protect and secure health data, and we need to understand the sensitivities around health data. So that is very important. In the past, we've seen that there was an attempt to bring in legislation to regulate the flow of digital health data. Disha Act, as it was called, was never enacted. But as it stands right now, the proposed DP, I think it remains to be seen. I think when it comes to the monitoring of data flows and how it will be sort of implemented. Even the DPA and the data protection bill would be the sort of a de facto in charge of privacy monitoring and ensuring compliance is concerned. So DPA's role, I think, is very important. While at the same time, the size of the ecosystem and swift changes that are happening in the sector, makes really wonder the capacity of the DPA, because the DPA has to regulate not just personal data of health tech, but financial, telecom. So really, the DPA has to have great capacity when it comes to regulation of this. So I think that's something which is important. I think current laws around data protection are inadequate. We have not finalized the PDP bill yet, as we all know. So health data is considered sensitive personal information and is prone to cyber attacks, cyber threats. So we need a more holistic approach to its cyber security. We also need adequate security frameworks that are working in harmony with other regulations to provide adequate grievances and redressal of grievances. Of the users of the system. We need a tiered structure of grievance redressal. I think that is something very important. The focus should be on enhancing user trust and improving the feedback loops, which can help in, let's say, iterating future changes. Now, because health data is sensitive personal data, sharing requires protection such as pseudo-minimization or anonymization. This would mean that there needs to be a clear indication of the anonymization standards to be followed for social and healthcare data. I think that is very critical. In India, we need to evolve these standards for sharing of healthcare data. So while the report of the Committee of Experts on NPD has suggested some possible, anonymization steps, we don't have really a consensus in terms of what can be implemented at scale. So it is crucial that when data sharing is to occur within the system, it is crucial, that we have solid anonymization standards. The manner in which data is shared, the protections that the persons sharing such data take before such data is important to note. So I think protections is critical here. As is the basis of any data collection processing, the purpose for which it is being collected has to be very clear. And the use, basically any other use must sort of have a fresh consent for collection of health data, and fresh consent should specify the purpose for which it is collected. Again, if there are any secondary use for which data is used, it is crucial to have it in the form of a policy legislation that would govern such secondary uses. So I think these are sort of some important aspect when it comes to health data. I think what we're looking in the future is with data laws and regulations from immediate use cases and prioritizing implementing. And what we need to look at is preventing harm, prioritizing to prevent harm. I think that is important. We need to have a more proactive response to protecting user data, especially healthcare data. Technology development is very rapid, and now with widespread data collection, profiling, sale of sensitive health data in black markets, increased cyber attacks on health data, there is a very crucial need to have a solid system and a checks and balance system in place. So there are developments in the health tech, health insurance, and pharma space which are taking place. Majority of these developments rely on data as a fuel, as a raw material. So while there is an economy which is coming up, which is booming, it is also important to make sure that the entire data cycle use, collection, processing is safeguarded, is protected, to make sure that at the end of the day, again, the user is at the center of this data revolution, and users' data has to be protected and safeguarded over
Yes. Thank you for commenting on the efficacy of data protection bill and the reality of having an exclusive piece of legislation, which would be futile if the institutions and the agencies that are vested with the responsibility of securing health data are not themselves independent, are not functioning independently. There's no point of having safeguards, because it lies vulnerable. The health data that is so sensitive and potentially dangerous to, if it gets exposed or leaks out, that harm needs to be adequately addressed exclusively or within the labyrinth of the data protection bill that the time will tell. So moving on and sort of expanding on the conversation and diverting from now the data protection bill and moving on to another paradigm of tech revolution, since we are the central basis of this conversation is talking about issues surrounding tech regulations in India. Um, the influx of artificial intelligence in India, and I know that there is no linear or concrete approach that comes to describing what an ideal framework of artificial intelligence would be, but uh, there has been a working or a white paper that was released by the government, I think last to last year, which talks about sectoral wise usage of deployment of artificial intelligence, um, and something that promotes efficiency, something that promotes non-discrimination, and is instrumental in economic growth as well. Now, there have been multiple literature. There have been. I've also interviewed authors talking about how their experience with writing about artificial intelligence has been, and the EU has played an active role in banning facial recognition, and we also talked about the criminal justice system. Um, do you think that what should be the ideal framework as far as regulating artificial intelligence, specifically from the point of view of proportionality, rationality is concerned?
Absolutely. I think AI, it's emerging as a, I would say, when we look at Web 3.0, which is the evolution of the internet from Web 2.0, which was, let's say, in the 90s and 2000s, it started with the use of static desktops and static web pages to we are going to Web 3.0, where we are looking at, technology which is real time, which is changing real time, which is evolving with large data points being collected, and the rise of metaverse, etc. So I think in this age of data collection, data processing, and the new economy, the tech economy, which is created from the growth of this evolution, rest a lot on the use of AI. And AI algorithms are used for multiple purposes. They are redefining the way technology is coming through. You're looking at AI algorithms for content moderation, you're looking at AI algorithms for law enforcement, you're looking at AI for the use of traffic, for the use of in the health tech, in the healthcare space, in the transport space, when it comes to other economic services as well, delivery services, you name it, AI is there. With the digitization processes, AI is sort of the foundation, and it will just keep growing and growing and growing. And we are coming to a time where we will be, preempting a lot of things, and a lot of things will happen in a much more faster manner, in a much more intuitive manner. So definitely AI is the future when it comes to the new tech economy. And therefore it is emerging as a very central policy issue, owing to its cross-cutting use and across the sectors. So for this, India has published two national AI strategies. In December 2019, a working document, Responsible AI for All, was released with the intent to develop an approach towards ensuring responsible use of AI in India. Following this, the working document was presented during a global consultation with AI experts around the world on 21 July 2020, and subsequently it was released by Niti Aayog for wider public consultation dissemination. And it basically envisages the principle-based approach for regulation of AI in India. At the same time, we're also seeing that the role of AI in judiciary is fast catching pace. There was an establishment of an artificial intelligence committee by the Supreme Court of India, and we've seen that three AI tools have been launched: SUPAS, SUPACE, SUBACE, and SCI Interact. Now, these tools will significantly impact justice delivery in India, but there is not enough information available on either of these. For example, which specific data sets these AI tools rely on, who is building these data sets, who is part of the committee, etc. So I think there is requirement for some more knowledge and understanding. I think there are certain factors and aspects which we need to focus on when it comes to the regulation of AI. Number one, we need to ensure that there is legitimacy at data level. While I mean regulating AI technologies for protection against harms, we need to have a regulation that cuts through. So more importantly, we don't need to wait for the technology to become an application before we think of regulating it effectively. So regulation at data level is important, depending on the sensitivity of the data sets. Now, for example, you may have seen that in case of predictive policing, which is now becoming really sort of growing and going ahead across the country, Lucknow Police's facial recognition systems, which they claim will send a distress signal by looking at the facial emotions of women. Here the use of data is critical to understand. Now, over here, we need to make sure that we have adequate checks and balances with how this particular facial recognition system is collecting women's data, and sort of what are the algorithm it is using to analyze the facial emotions. Are there any biases or not? Let's say someone data is being used against her and the community to which she belongs, then it needs to be regulated at the data level before we go to an algorithm level. So we need to make sure that we have unbiased data, we have clear data, and we have protected this data, because we've seen that facial recognition systems quite often are not accurate when it comes to sort of predicting or analyzing the way it is trying to sort of catch hold of criminals or even protect people at the same time. So we have to have solid regulations at the back end, as well as have great checks and balances from a technical point of view to make sure that data is protected and it's not abused or misused, etc. Uh, on the checks and balances, I think we need a data protection law. I think we've spoken enough about it, but again, cannot understate and cannot really emphasize how important it is to have an effective data protection law in India to protect privacy. So you want to bring in AI for law enforcement, you want to bring in facial recognition systems, but then you don't have a law which protects users' data, and you don't have a law which makes sure that user data is adequately secured. So I think we need a baseline regulation, which is important. Now, self-regulation is a viable option, but there needs to be a necessary checks and balances, and regular publishing of transparency reports regarding the types of data, algorithm being used, designing and deployment, ensuring third-party audit. These are some of the key things which have been discussed and are being debated globally. So I think that's something which we can look into. And I think we also need to make sure that we counter the bias in the algorithms which are deployed when AI is sort of delivering the services. Analysis of data shows that by the time 50th judge of the Supreme Court will be appointed, 32% of Chief Justice would be male Brahmin, for example. Another set of data shows that only 11 Supreme Court women judges in 71 years. So such appointment imbalance shows inadequacy and biases of judgments. It could be in the future on gender and caste. So I think we need to be very clear that we are countering some of these biases. There is inclusivity when it comes to the uptake of AI. This may seem, of course, fairly obvious, but it means that inclusive training data wherever possible. Another important element to consider with AI intercept technology is the nature of job loss, right, which will be borne unequally by women across the world. So gender justice in the workforce is a concern of immense importance, which must be addressed when it comes to the future of work. We need to have more women involved in the creation of algorithms. We need to have people from diverse background, diverse communities, different caste and gender into the development of these algorithms. Only then can we ensure that we are able to counter the bias and have more inclusivity in terms of how AI is processed going forward.
True, because there has been a lot of considerable research which says that discrimination tends to seep in when it comes to the actual application of AI in different sectors and different landscapes is concerned. So my last question to you is something that is very different from what all we've discussed about, going into the details of the PDP bill, talking about the future of AI in India and the regulation that seeks to have a clampdown on its overarching extent is concerned. Can you please take us through the crypto market crash that happened last to last month, if I'm not wrong? And that happened in the wake of the passing, if not the passing, but the discussion that was the bill that was tabled on the parliament, which was the Cryptocurrency and Regulation of Official Digital Currency Bill 2021, that is sought to be passed. And now, as far as my limited knowledge is concerned, that restricts the uh, private cryptocurrencies only to the purposes of research. And what, according to you, does that say about growth in this sector, regulation, and just generally governmental intervention? Or is it the same pattern that we are talking about, or is it something that's slightly different? What is its strategic implementation as far as that is concerned?
So I think it wasn't really a crash; it was a sort of a dip for a temporary period. But I think the news of cryptocurrency bill tabled on in the parliament did result in a lot of speculation and panic. So but it cannot be extrapolated towards any larger statement on the state and scope and growth of the crypto market, right? So cryptocurrency as well as underlying blockchain technology have huge potential to form as an essential part of the global economy. However, the market, I think, is going through a natural maturation sort of process. It's still maturing. It's in a very nascent early stages and requires a lot of consumer education, awareness, and most importantly, progressive overall regulation before its volatility approaches relatively normalized levels. So I think cryptocurrency has many use cases, and this is something which we've been seeing and discussing over the last 1 to 1.5 years. It has the potential to supplement modern financial products and services. I think sort of starting with payments, Bitcoin and other cryptocurrencies enable sort of cheap and rapid transfer of money across the world, as well as providing access to financial services for the unbanked. So there is potential over here, but of course, you need a strong regulatory ecosystem to make sure that any potential abuses are prevented and any sort of potential crimes are tackled at the same time. I think those two concerns are very legitimate and valid, and we need appropriate regulation for that. Again, it provides access to credit. Example of the potential of decentralized finance is the scope of cryptocurrencies to improve access for credit for the masses. Then these services, are enabled using smart contract and allow for cross-border trading, cross-border lending. So there is another benefit over there. Asset tokenization, the growth of crypto, and especially the expanding functionality of tokens is making possible to tokenize real world assets, right? So this extends from IP to art pieces, real estate, helping bring liquidity to these markets. Additionally, buying and selling of these assets is becoming cost effective, fast, and also very transparent. So I think that's another advantage. Then the store of value, aside from providing decentralized financial services, what we're also seeing that crypto coins and tokens can also act as a store of value. So from this basket, Bitcoin is looked at as a very relatively, let's say, stable investment instrument, and maybe a potential hedge against inflation as well. So this is possible due to crypto largely employing better supply mechanisms that restrict inflation and may increase in value with the rising demand. But of course, that is to be seen in the next coming years. I think looking at the Indian crypto bill, the broad description provided has not changed since being listed last year, and thus it led to speculation regarding the contents of the bill. But the government is very clear that they will not be banning crypto, right? So there should be more optimism. There should be a lot more. There is hope. There needs to be more optimism in terms of how the government is going to regulate crypto. And there are a lot of discussion going on in terms of what should be the process around which government should be regulating crypto. And I think they've been very clear, and the finance minister has said in the parliament that they are not looking to ban it. So I think we don't need to sort of panic over there. There are the only sort of revealing aspect within this description is that the government is now reiterating the desire to have a central bank digital currency, and that is something which the government is sort of looking to have. Now, there are many classes of cryptocurrencies that private and anonymous blockchain transaction that power. Sorry if I may repeat. There are a lot of cryptocurrencies that power private and anonymous blockchain transactions by sort of obscuring their origin and destination. So it is important to highlight that prominent coins such as Bitcoin, Ethereum are public cryptocurrencies and do not come under the ambit of sort of private cryptocurrencies. On the whole, there has been significant discourse, consultation. So let's see how this sort of goes ahead, how the government regulates cryptocurrency, what the bill contains, and what are the sort of pillars and different aspects of the bill. But it is interesting to see that there is a lot of movement happening globally, and in India also we are recognizing policymakers, especially, that there is a need to regulate crypto.
So that brings us to the end of the interview. Um, I would say that this has certainly been one of the most comprehensive conversations on the issues surrounding tech regulations that people are like completely unaware of. Even in the policy and in the legal fraternity, we are yet to be equipped with the challenges that lie ahead of us. Now, whether it comes to the fixation of the opposition that is on clause 35 in the PDP bill, or whether it's about the spraying down of on the anxieties that concern about the upheavals that the market sees when some tech advancement happens, or whether it's about containing governmental intervention and containing the powers that the tech companies enjoy or over the user data, or how they dictate the narrative on free speech, or how they dictate consumer preferences. All of this I think circles back to PDP. All of this circles back to the paramount importance of data as a oil is concerned. I wouldn't think of any other important time when there has to be a law in place for protecting the data privacy of the citizens is concerned, and most importantly, to define it in the proper light, to clearly lay down the distinction, because there should be no scope for overlap or blurred lines is concerned, because that's going to eventually have a ripple effect in the strategic implementation of these laws in the future, as far as the future is concerned. So I would once again thank you for taking out the time and delivering this interview on such a short notice on such an important monumental topic, and all the best for your advocacy and research that you continue to do, that your organization continues to do on so many fronts. And thank you on behalf of the team, and it will be up and we shall discuss the up the we will discuss the nitty-gritties of the interview before we upload it, so don't worry about that as well. But it was a pleasure engaging with you, and take care.
Thanks a lot. Thank you so much.